One hears a lot of talk about human rights these days, but many of the new rights that one hears of, such as reproductive rights interpreted to include a right to abortion, or rights based on sexual orientation and gender identity, actually sound a lot like wrongs. Indeed, as one friend of ours and colleague Jakob Cornides has said very succinctly, what was once considered a crime is to be transformed into a right, and what was once considered justice into a human rights violation. The stage is set for a clash of competing rights, as rights based on these novel concepts insinuate themselves into human rights discourse, and the state is called upon to enforce such newly fabricated rights. Sexual orientation is a nebulous term not defined in international law in any binding sense. And on its face, if you look at the term sexual orientation, it implies an inward disposition or orientation. However, it is deemed by some to extend beyond an inward disposition as something that must necessarily manifest itself in forms of behavior that have traditionally been considered deviant, harmful, immoral, and in certain cases, criminal. Now, those of us who continue to believe that this is the case and state this publicly out of a sense of obligation to the truth as well as to charity, then become attacked as human rights offenders. I mean, you look, for example, the brave example of Bishop Rij Pla here in Spain. What then happens to fundamental human rights, such as freedom of religion, freedom of conscience, and freedom of expression? This raises the question of what are human rights, where do they come from, and what is the relationship between human rights and the state? As was mentioned yesterday by Alan Carlson in his opening remarks, modern human rights discourse dates back to the Universal Declaration of Human Rights of 1948, which in turn grew out of the horrors of World War II and of the Holocaust, that was perpetuated by Nazi Germany, where the law and state power, positive law, was unchecked by any reference to a higher law. Charles Malik, whom Alan referred to yesterday, asked, I think, a very important question of where rights come from. And I'll read to you this because I think it really succinctly hits upon the issue. By what title does man possess rights? Are they conferred upon him by the state or by society or by the United Nations? Now, if they simply originate in the state or society or in the United Nations, it is clear that what the state now grants, it might one day withdraw without thereby violating any higher law. But if these rights and freedoms belong to man as man, then the state or the United Nations, far from conferring them on him, must recognize and respect them. This is the question of whether the state is subject to a higher law, the law of nature, or whether it is a sufficient law unto itself. If it is the latter, then nothing judges it. It is the judge of everything. But if there is something above it which it can discover and which it can conform, then any positive law that contradicts the transcendent norm is by nature null and void. Now, this framing of the issues by Charles Malik is very important as we assess this conflict of rights brought on by those who advance novel notions such as rights based on sexual orientation. And one distinction of rights, I think, that's very important is a distinction of rights as negative rights versus positive rights. And here, let me clarify. When I say negative rights, these are not bad. When I say positive, it's not necessarily good. Rather, negative rights are rights that we hold against the state. They are grounded in nature, and the state cannot infringe upon these rights. Therefore, they are negative. Positive rights, however, are those rights which the state grants, okay? And rights which the state grants, as Charles Malik said, it can also take away. And the substance of such rights can either be bad or good, depending on who is infusing the law with its substance. To help illustrate this difference between positive and negative rights, look at the right of education in the Universal Declaration of Human Rights. The Universal Declaration of Human Rights, and I think one of the most beautiful phrasing, says that parents have a prior right to choose the kind of education that shall be given to their children. Note, this right is grounded in nature. It is prior to the state. The state can only recognize it, hence it is a negative right. But the Universal Declaration also speaks of education as a positive right. Listen to this phrasing. Everyone has the right to education. Education shall be free, at least in the elementary and fundamental stages. Elementary education shall be compulsory. Note the much larger role of the state plays in this positive right to education. Now, what happens when the substance of educational policy is formed by people such as President Obama or Zapatero here in Spain? In Spain, in fact, you saw very recently a citizenship education program that infringed upon that prior right of parents with regard to subjects such as sexual orientation. And it sought to force a positive right, a positive content upon parents and children. Now, this same agenda, the Zapatero Project, also has an analog in international law, and it is called the Yogyakarta Principles. The Yogyakarta Principles purport to be a statement, quote, concerning the application of international human rights law in relation to sexual orientation and gender identity, as well as a universal guide to human rights which affirm binding international legal standards which all states must comply. It is no such thing. It is an illustration of what Austin Roos just spoke about a few minutes ago. What it is a group of 30 so-called experts from left-leaning organizations and from UN treaty monitoring bodies getting together and fabricating a set of rights, and then seeking to use the United Nations process, the treaty monitoring bodies, the special rapporteurs, to create a fabricated norm which activist lawyers then use in court cases around the world to try to create rights based on sexual orientation. It is modeled after the parts of the Universal Declaration of Human Rights, but in effect, it undermines those principles in the Universal Declaration of Human Rights that speak of true rights, of negative rights. It is also based upon anthropological notions that I think we all believe are false. Human sexuality, sexual orientation, gender identity, according to the principles, is a fluid social construct. This is how it defines sexual orientation. It is understood to refer to each person's capacity for profound emotional, affectional, and sexual attraction to and intimate sexual relations with individuals of a different gender or the same gender or more than one gender. Think about that. Of more than one gender, would that be two genders? No. For again, gender is a fluid, malleable social contract, a concept. There can be a multiplicity of genders. Now, the clash of rights, I think, is illustrated by a number of the Yogyakarta Principles. For example, Article 19 affirms that everyone has the right to freedom of opinion and expression regardless of sexual orientation or gender identity. And as far as that goes, that is true. Okay, that's a statement of a generally universal right, the right to freedom of expression and opinion. However, it then goes on to comment that states shall, again that positive, states shall ensure that the exercise of freedom of opinion and expression does not violate the rights and freedoms of persons of diverse sexual orientations and gender identities. What does that mean in practice? Well, we've seen again, for example, when Bishop Rij Pla speaks from the pulpit on the sinfulness of homosexual conduct, then that is deemed to be an infringement and the state is called upon to punish him. Or Pastor Ake Green in Sweden, who is prosecuted and convicted and sentenced to jail for speaking the truth from the pulpit about Romans. The same thing happens with freedom of thought, conscience, and religion. The commentary to the Yogyakarta Principles says that states shall ensure that the expression, practice, and promotion of different opinions, convictions, and belief with regard to issues of sexual orientation or gender identity is not undertaken in a manner incompatible with human rights. We also see this conflict in the way that family and education is to be taught. The Jakarta Principles advocates educational policies that undermine the role of parents as the primary educators of their children and would expose children to homosexual propaganda. For example, Jakarta Principle 15 assumes that children are capable of identifying with a particular sexual orientation and gender identity, which will sometimes be opposed by families. And because families will impose that, there's a need for state intervention, state social services, with social programs to address factors relating to sexual orientation or gender identity among children and young people who may suffer rejection by families. The principles state that educational curricula resources must serve to enhance the understanding and respect for diverse sexual orientations and gender identities. Governments must ensure training at all levels of public education to promote standards in accordance with these principles, as well as to counter discriminatory attitudes based on sexual orientation and gender identity. Remember that statement of positive law in education in the Universal Declaration, public education shall be compulsory. Well, what happens then when people who are driven by this agenda inform the substance of what is taught to our children? Here, I think, is the danger. Government seeks to fill in the spaces that are the rightful domain of families, of the churches, of mediating institutions. One side of this battle has found a way to enlist the state in the battle over human rights. Okay, they are unrelenting. The pressure is tremendous. The reality is that those who are seeking to inform the substantive content of such rights are often the people who are agents of the anti-culture of death, be it death in the form of abortion or in modes of living, modes of behavior that are inherently self-destructive. Who will win this clash of rights depends in large part as to who can seize the moral high ground and control the terms of debate. Now, I think the terrain of our choosing then is to recapture a notion of rights as negative, rights that Charles Malik spoke of. Rights do not come from the state. Rather, they are inalienable, they are grounded in nature, and the state can only recognize them. I think if we recapture this notion of negative rights, the outcome may very well be quite positive. Thank you very much.